Hey everyone, U.S. immigration lawyer Michael Ashoori here, and in today's video, I'm gonna outline the process through which someone can get an employer-sponsored green card. For those of you that don't know, there are ways for foreign workers to get a green card to the United States based on having a full-time job offer from a U.S. employer. In this video, I'm gonna basically outline the step-by-step process that takes place in order for somebody to get a green card through this process. So without further ado, let's get started. The employer-sponsored green card process, whether it's through EB-2 or EB-3, which are the immigrant visa classifications that apply to the employer-sponsored green card process, either of these categories require you to have a full-time job offer from a U.S. employer. The job should be considered a permanent job, so it shouldn't be seasonal or temporary work. It should be a traditional full-time job, and it should be a permanent position. This whole process starts with the Department of Labor. Before you do anything with USCIS, you have to start off at the Department of Labor. And we're going to outline in a moment what specific steps that you need to take. But just so you know the general idea, the regulations are set up in such a way so that a U.S. employer can't just go and hire somebody from another country and sponsor them for a green card to be able to hire them and pay them less than what a qualified U.S. worker would get paid. So in order to ensure that, the immigration regulations require U.S. employers to first test the U.S. labor market and try to hire a qualified U.S. worker for the position. So that's just some general background information. That brings me to point number one, which is the prevailing wage determination. As I just mentioned, the immigration regulations require the U.S. employer to pay whoever they would be sponsoring for the green card the same amount that they would pay a similarly qualified U.S. worker. So at this stage, at the stage of the prevailing wage determination, the U.S. employer has to basically submit a prevailing wage request to the Department of Labor. And in the prevailing wage request, the U.S. employer specifies what the job is going to be that they're hiring someone for. What is the job title? What are the job duties? Where will this job take place? What is the experience that is required for the position? What is the degree that is required for the position? All of this information gets put on the prevailing wage request and it gets submitted to the Department of Labor. The Department of Labor will then review that request and will make a prevailing wage determination. The prevailing wage determination is the rate that must be paid to the foreign worker that you will be sponsoring. Let me rephrase. That rate that the Department of Labor comes back with is the minimum amount that must be paid to the foreign worker. So let's say you submit a request and you say that I want a software engineer with 12 months of experience and a master's degree, and they're going to be working in New York City. Well, then what's going to happen is that the Department of Labor is going to take all that information on the prevailing wage request, and they're going to come back with a wage. Let's just say for this example that wage comes back at $90,000. Well, what that means is that in order to proceed with the process, the U.S. employer essentially has to agree to pay at least $90,000 to the foreign worker for that position. And by $90,000, in this example, I'm just referring to an annual salary. But the U.S. employer would not be able to pay less than that amount. So they would have to at least pay that amount or more. Another important point that I want to mention is that the U.S. employer needs to demonstrate that they have the ability to pay the prevailing wage. So that's something very important for the employer to consider. There's various ways that the U.S. employer can demonstrate to USCIS that they have the ability to pay the prevailing wage, but it's something important to consider is that down the line, Once we get to these later steps where you're actually moving from the Department of Labor and now submitting an application directly with USCIS, USCIS is going to want proof that the U.S. employer has the ability to pay the prevailing wage that is determined in step 1. So let's move on to step 2, which is recruitment. After you get the prevailing wage determination from the Department of Labor, the next step is to begin recruitment. As I mentioned in the earlier part of this video, the Department of Labor wants to make sure that you tried to hire a U.S. worker. Again, this whole process is designed so that U.S. workers are not getting harmed by having foreign workers come to the labor force. So this next step, this step of recruitment, is to ensure that the U.S. employer tried to find a U.S. worker first for the position. So again, in this step of recruitment, there are very technical, very specific ways that the U.S. employer has to try to find a suitable U.S. worker. They have to post newspaper ads, and there's various other methods of conducting this recruitment, and it's very important that the recruitment is done properly. Again, the recruitment is highly technical. The specific language that has to be in the ads and all the various things that need to be done are very, very technical, so it's very important to work with a qualified immigration lawyer in this process. Now, after all the recruitment is done, there is a mandatory cooling off period, and this cooling off period is so that the U.S. employer can basically allow applications to trickle in from all the recruitment efforts that were done, and to see and go through the various applications and conduct the interview process to see if there's anyone qualified for the position. Now, after steps 1 and 2 are done, then the U.S. employer can submit the PERM application. The PERM application is submitted to the Department of Labor in order to get authorization from the Department of Labor to now proceed and move ahead to sponsor the foreign worker for the position. Basically, what you're saying is that you've gotten the prevailing wage determination, you've conducted your various recruitment activities, and you were unable to find a suitable U.S. worker for the position. So now you want authorization from the Department of Labor to be able to hire a foreign worker for the position. And again, that is done by submitting the PERM application with the Department of Labor. Once the PERM application is certified, the next step is directly with USCIS. So steps 1 through 3 are essentially done through the Department of Labor. After that, you're now dealing with USCIS, beginning with step number 4. Now, step number 4 is to file the form I-140 with USCIS. Now, with the form I-140, you're going to submit evidence that the foreign worker that you're petitioning for satisfies the requirements that you laid out in the prevailing wage determination and in the PERM application regarding the experience required, the education level required. So again, the form I-140 is submitted with USCIS, and the next step, step number 5, is to either do an adjustment of status or to do consular processing. Doing an adjustment of status or doing consular processing, this is basically the last step in the equation, and whether you do an adjustment of status or consular processing will depend on where the foreign worker is located. If the foreign worker is physically present in the United States in some sort of valid status, for example, maybe they're in the United States on an H-1B visa, or maybe they're here on a student visa or something like that, potentially, then an adjustment of status may be a viable option for them. The adjustment of status is the process of converting from whatever non-immigrant status that you're in to lawful permanent resident status. As the name suggests, you are adjusting your status from non-immigrant status to lawful permanent resident status, and that's done through the adjustment of status. If you're outside of the United States, then you will likely do consular processing, which is where you go to a consulate or embassy and you have a visa interview, and then upon successful completion of that visa interview, you'll get an immigrant visa stamped into your passport, and then you enter the United States using that immigrant visa, and upon your admission to the United States, you're now a lawful permanent resident, a green card holder. So a few more points that I want to mention about steps number 4 and 5. In certain situations, you first have to file the Form I-140 and get the I-140 approved before you can move to step number 5. But in certain situations, you may be able to do steps 4 and 5 concurrently. In order to do steps number 4 and 5 concurrently at the same time, that means that there must be a visa number available at the time the Form I-140 is being submitted. Basically meaning that there is no visa retrogression, that the priority date is current. Now, I could go into a lot more detail about what that all means, but what I want to limit it to for this video is to know that in certain circumstances, you may be able to concurrently do steps 4 and 5 at the same time, which can help you save some time. But in other cases, you're going to have to first file the I-140, get that petition approved, and then depending on your country of birth and other similar factors, you may have to wait a period of time. In some cases, it may be a significant period of time before you can proceed with step number 5, which is either the adjustment of status or consular processing. So there you have it. I know we went through a lot of information in this video. I hope you got a lot of value and you learned a lot from this video. But basically, the big picture is that the process of sponsoring a foreign worker for a green card in the United States is not just a simple one-off application that gets submitted. There are multiple steps that take place, and as we discussed, it starts off with the Department of Labor, and then it moves over to USCIS. And depending on where the foreign worker is located, there may be a last step that even involves a consulate outside of the United States. Thank you so much for watching this video. If you like this information, if you like this video, please give this video a thumbs up. It helps YouTube know to share this information with more people. Again, thanks for watching, and I'll see you on the next video.